Hey, Christine Faulkner with Cava&Faulkner. Thanks for tuning into another edition of The Daily with Christine. I am an estate planning attorney with Cava&Faulkner located in Elk Grove, and I am also a living trust and estate lawyer in Sacramento, California, serving Sacramento County. Today, we're going to talk about Victoria's Secrets and their recent litigation with their lessor and how really the importance of language and legal documents, it applies across the board, whether it's a commercial lease, a residential lease, or your estate planning documents, how important the language can be and how it can really bring unforeseen consequences and unintended consequences. Maybe not unforeseen, that's actually not the right word, but unintended consequences. So stay tuned, because we are going to talk a little bit about what happened in the Victoria's Secrets case and how, paying attention to language. Each word has meaning, and maybe people don't realize that, but it actually does. So here's what happened with Victoria's Secret. So they have a flagship store in Manhattan, and I'm not sure exactly where it's located, but it's Herald Square, I believe. And so they had a flagship store in Herald Square, and during COVID, they had to shut down. They were required to shut down by the state and stop paying their lease. And so this is obviously a really sizable space that they were occupying. Plus, it's in New York City, and they had a number of other, of course, stores in New York City, but this was their flagship, meaning, right, they're the biggest store, kind of blasting out their brand to New Yorkers and to the world, all of the visitors who came. And so COVID hits, they have to shut down, and they stop paying on their lease. And so they're involved in litigation now with the landlord, who is trying to enforce the lease and probably get them to pay the arrears. And their position was, hey, wait a minute, this was an unforeseen circumstance, this COVID-19. Nobody saw it coming. Plus, we were mandated to shut down by the government, by the state of New York. And so we have a right to basically get let out of our lease because we could not. There is a frustration of purpose, which is a contractual term, but that the purpose of the contract was frustrated by COVID and by the state shutdown. And so they argued that there was no allocation of risk for these kinds of events in the contract, and therefore they should not have to be held accountable to pay their lease. And apparently they did not reopen, or if they reopened, it was only for a short period of time and closed again, and so ultimately wanted to get out from the obligation of the lease. And so the landlord basically argued the terms of the lease account for this kind of risk, account for store closures in the lease agreement itself. And when the parties contemplate a specific risk and contract for it, meaning they negotiate for it, that is clear intent that this was a risk that was contemplated by the parties at the time of the negotiation, at the time they entered into the contract. And in this specific contract, store closures were contemplated in the contract itself, and Victoria's Secret agreed to accept the risk for store closures, and obviously being mindful of the impact on their bottom line and their ability to pay their lease. So there was that language that was in the actual lease itself. And so the court said, no, you're not going to get out from under the obligations of paying rent, because you negotiated and bargained for this and accepted the risk of store closures. Victoria's Secrets also tried to play the emotion card, which is, hey, this has hit us really hard. It's not fair. Even if we did contemplate the risk, it wasn't something like this. It wasn't contemplated under governmental shutdowns. And so therefore that should be treated differently. And one of the attorneys for the landlord basically went shopping and went all over Manhattan and showed that although this particular store may have been closed, they were able to shop at other stores, including another Victoria's Secret location in a different area of Manhattan, demonstrating that it was basically the company's choice to keep this store shut down, that other stores were back up and running and doing business and able to make money, to make an income. And so why have they not been able to open? And basically it's not the landlord's problem that they made a choice not to reopen. And one of the other things that the court made note of is that there is no force majeure clause in the lease agreement. And so that brings me back to my days of entertainment law. And so force majeure is another way of saying an act of God. And unfortunately, there was no force majeure clause in the lease agreement. Usually force majeure clauses say if it's an act of God, then there can be some relief. And there's usually a definition of what falls within, what is encompassed within that definition. But unfortunately, in this particular case, there was no such language in the contract, potentially relieving the tenant of their obligation to pay rent. So interesting. I think that there was some other behind the scenes going on commentary about possibly the owner. I can't remember the owner's name. His association with Jeffrey Epstein and how the bad PR could have really been the underpinning of Victoria's Secret's not opening, that their brand in general is not doing well. And that was really the behind the scenes of what was going on. So the moral of the story is, believe it or not, precision in contract drafting, which includes estate planning documents as well, is really important, and every word can count. Shall, may, if, when, all of those words in the English language in legal terminology can have very real and different meaning and impacts on the parties to the contract. And so when it comes to estate planning, I'd like to say that I think that many people are under the impression that, these are just template documents and lawyers are really not doing us any favors by creating a plan. I can just go online and use, LegalZoom and come up with the same document. The quick and dirty answer is no. That's not the case. There is some standard language that goes into planning documents, but much of it is customized to your exact needs. And believe me, the language that is incorporated into your planning documents, into your leases, into your legal contracts, it is important that it be precise so that it carries with it the meaning that you intend when you enter into the contract, or in the case of an estate plan, when you create your estate plan. You want it to have the impact on your loved ones that you expect, not some unexpected outcome. So a little tidbit about Victoria's Secrets, and I thought it was interesting and newsworthy. I thought you might like to hear about it. So thanks for tuning into the Daily. Like our channel, subscribe to our content if you like what we're doing, and let us know what you'd like to hear about. Take care. See you soon.